to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complaining about it.
Today, we've got a sovereign citizen who might just take the crown for being the most unprepared ever. Seriously, how do people like this still exist in 2025? This guy struggles to read, but somehow believes he can stroll into court and outmaneuver a seasoned prosecutor. His biggest gripe: he only had an hour to study law, while the prosecutor spent 7 years in law school. That's like entering a marathon with zero training and complaining that the professionals had more time to practice. This is going to be rough to watch, but let's be honest, also pretty entertaining. Drop your thoughts in the comments, and let's dive in to see how this train wreck unfolds.
7ST and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or inadequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct.
This guy can barely read, yet here he is in court, throwing around legal motions like he's a top-tier attorney. Be honest, what do you think his reading level is? I guess maybe 6th grade, and that's being generous. But the real kicker, he's actually complaining that he didn't have enough time to study law. Does he really expect the judge to put the whole case on hold for a few years so he can go to law school? The entitlement is off the charts. The court laid out his choices plain and simple. Hire a lawyer, get a public defender, or represent himself if he knows what he's doing. Spoiler alert, he doesn't. What's next? Asking for a delay so he can work his way up to the Supreme Court.
For every waste of time and the more money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court. And for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions, making sure my rights were protected. And Rules 4.3, if they...
Is this guy genuinely clueless, or is he just putting on a show? I'm leaning toward the latter. Because come on, no one can be this lost while facing real jail time. This isn't some last-minute school project where you can just improvise and hope for the best. The wildest part. He had access to a free, court-appointed lawyer. But instead of taking the help, he spent his time filing nonsense motions. Then turned around and complained that he didn't get enough time to study law. Did he seriously think this was a take-home test? He's like that one kid in school who didn't do the homework, so he just started making things up, hoping the teacher wouldn't catch on. Spoiler, we all caught on.
Stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to.
Got to give credit to the judge. She handled this way better than she had to. Sure, she could have shut him down sooner, but then we wouldn't have gotten this comedy gold. What exactly was his plan? Stroll into court, ramble for a bit, and magically talk his way out of trouble. He could barely even read the crumpled piece of paper he brought with him. This is why understanding your rights actually matters. Not so you can invent legal arguments, but so you don't end up like this guy, embarrassing yourself in front of a judge who has zero patience for nonsense. Courts don't entertain this kind of thing. The judge gave him a fair shot, even offered legal advice, but when you refuse free help and argue nonsense, you can't expect anyone to take you seriously. Honestly, this might be one of the worst legal defenses I've ever seen. The law isn't some choose-your-own-adventure book. You don't get to make up rules as you go. But hey, at least he gave us some top-tier entertainment. What do you guys think? What reading level are we working with here? 6th grade? 3rd? Either way, it's not looking good. If you enjoyed this, don't forget to like and subscribe. Drop a comment if there's a court case you want me to cover. I post daily, so I got you. Thanks for watching, and I'll see you next time.
With that, I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that, and you didn't want that either. So then we went through the hearings, and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws stating and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you
gave me
wish.
bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is, one, serving a sentence, two, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, and he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new trial along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually